Mimobi bi akwaba eba Melodies TV so. This is an update on the case involving Gifty Oware Mensa. Na muni amukai say national service scandal eba bonteno ono ena oye one of the people awomudi enim say allegedly no omo sika. You see, I've said something say people need to realize say enyo obi anasem ye den nkwana de bia owini e court. Na lawyers no ebi munim sade, especially in a political case. We've carved a niche for ourselves as a country in political cases. And sadly, no, it allows politicians to run away with stolen money. Now, the yomo yene say onim say we sika, ya chine say we sika. Now some of the assembly court, they will try as much as possible to drag the matter. Chombe dragi asemna beye diombe ya wombe dragi asemna in hope say the political party ebe baso. And the political party baswa obviously umeba be cancel case no, and it happens. Now what should the air court with Gifty Oware case now? I'm not saying that that's the same thing, but it looks like there is a pattern that is going on. Now court no ama order Gifty Oware ne lawyer enso edi asem ako Supreme Court. Na Osre court no say onye bibi mano case ne bekwa akwa wie sen. And then your first time or subscribe na click the notification bell ne so oye ne say latest news bi aba onsa ebeka na meguswa kan mo say Novdek eba say owoba ana owo fa sibi na ne wasi results na nkoye na opeso tron of deka a school back open na me recommend ya Sanctuary College. The only reason why I am recommending this school and it's a obi biara or register Novdek with omo our trobiano e pass with flying colors. And so register frewomo e was 053 77 30272 omo dansoman. They have hostel facilities what you see now. NHSM they said they have a WhatsApp platform which is free. Obetumia joining na teachers are a wohono or more try there a bisan kolane questions. What you say kolane the questions but teachers no answer. Link no comment box ni the last link. Comment box ni mo links mi ensa na wo the last link. O click here na wa join amaye. Me sanso kai will say book na a dash screen is on your friend the Ghanaian investor. Na sa book we ebetrel secrets to investing in Ghana. Secret investments institutions any omo investment packages bia omo awo munim no omo di disikapan ewo Ghana. This book is going to show you all those secrets. Pebinato ope hard copy for the book oko Amazon now type the Ghanaian investor you are going to get it. So ope book no ewo WhatsApp so ope PDF and also open a tree video and open the English video free and also WhatsApp is 055 807 4986. There is also a link in the comments box, the second link. At yes, here, or click here, you get the book downloaded on your phone, and then the partial. Now, young consent must say order forcing Gifty Oware to list witnesses contravenes constitution. Lawyer tells court seeks Supreme Court interpretation. Now, when you say case eba ni edi ewo quarter wa ye peja case no etia no, you can decide to bring a witness, and then the state is also supposed to bring a witness. What you say witnesses no and on better na say what you say witness never any be hu ne so mo so be come asem ne hu ne so ki asem ne se ne koko wie ye se ne sie what is that na say yes into we share Gifty Oware ni case no senior air corner ya man order say unlist a year ne witnesses onfa ne witnesses emra na case no ento so na wonya de ne witness ba na yeto case ni so na say it simply means that the case is progressing, but apparently the lawyer no reject some move no enti opeso de court Supreme Court na Supreme Court interpretation ba na Supreme Court etre se ebia sa order na court no man no eye no kware anase enye no kwa we be say na we eye asem. I mean, I don't know the motive, but obia be di adanse say a case no if it's supposed to last for 10 days na in sembi say e pejanitia, obviously the case is not going to last for 10 days anymore. It's going to, because at every point you see that be rejected, at every point you file motion, at every point you bibia time I expect to say case no be running, no. Obviously your case will not be running, right? Now yanking kind, this is coming from the fourth estate for nankasa and this are expose we ebae. I say the lawyer for the former deputy executive director of the National Service Authority, Gifty Oware Mensah, says an Accra High Court order requiring his clients to file the names and addresses of her witnesses before the start of trial is inconsistent with the 1992 Constitution. Gary Nimakumafo argued that the portions of the practice direction based on which the court orders his client to file a list of witnesses contravenes the Constitution. Inti M said Gary Nimako. Gary, I don't know whether it's the same Gary Nimakwa or ye MPP for lawyer Pinyi. Inti onona or ye mameno ne lawyer. Interesting. Also, the contention of the applicants is that upon a true and proper interpretation of Article 19(2)(c) of the Constitution, the provision in the practice direction disclosure and case management in criminal proceedings 2018, which compels an accused person to disclose the names and addresses of all witnesses he or she intends to call at the case management stage, is inconsistent with the presumption of innocence of an accused person guaranteed under the 1992 Constitution, he said. Also, the practice direction is a Supreme Court document produced in 2018 and signed by the former Chief Justice Sophia Kufu. It governs criminal cases in all courts with criminal jurisdiction in Ghana. However, Mr. Mafo contended that because Article 19(2)(c) of the Constitution says a criminally accused person shall be presumed innocent until proven otherwise, and Section 11(2) of the Evidence Act 1975 puts the burden of proof on the prosecution, the court's order for his client to file witnesses pre-trial is in variance with Ghana's apex law. Okay. Inti Ghana mra etre se yedi obi kokota ene interese nipa kro no se yedi asem to ne so se wedi boni a ene interese nipa kro no wedi boni. I was say court tina se na court hwe inkrata mu evidence eda nanim na court ema ruling na nsa na betumi aka se nipa kro no wedi boni ana so ndi boni. Nti at this point, according to Ghana mra no, Gifty Oware Mensah unwie sika bia because court enyam presume say we wi sika, right? And a court enyam assume say we wi sika. The lawyer asemo a work can say pre-trial no ye mama me no eba be listing the witnesses any omo addresses omo file the addresses of the witnesses are, then it means say court no indirectly no agiatum say Gifty Oware no wabokro no. That is what his lawyer is saying. Say ye file witness ne dia na tre say court na agiatum say wabokro no. Meanwhile Ghana mra say yenyen di asem ni wie ya ne pakro no yentumi mfa nto ne so say wabokro no. Nti eno hunti no mo say omoko eye Supreme Court no. As such, he filed a motion asking the High Court to suspend the criminal trial. To catch court no say unsuspend the trial, and I've told you it happens with a lot of cases. I am not saying say directly Gifty Oware Mensah ne lawyer ni nim say case ne yedin ana so won to me ana, but un notice here once lawyers ehun say case be evidence ni tia wo mo ene enye we ya, it is not about the case any longer. It becomes shenanigans. What you say, it becomes the outside matters. Case ne kra no yem person for at this time because nyama bi ekoso no ye ninje ho and the case ne kra yen twentwen so at this time, and that's exactly what's going on. Ohwe edubu ahen case na, that's exactly what's going on. and there ye ko file motion we and there ye ko ye we case ne kra yen pose no and ye case ne kra nyama bi e ko se ne nko so ye nti for now ne de yen twentwen so and that is a political ohwe Ghana okọ back na wo hwe most of the political cases are sa niche no and ya carve ama ye ho. Also, this portion of the manual indicates that without prejudice to the constitutional presumption of the innocence of the accused person, the accused person shall, for purposes of case management, disclose the names and the addresses of all witnesses he expects to call. Also, should the court call upon him to enter into his defense at the close of case for the prosecution. As Mr. Marfo made a vociferous case against this provision, interspersed with periodic water intakes, that because the Constitution did not state without prejudice anywhere in 192C, the practice direction cannot contain without prejudice to compel an accused person to file a list of witnesses. But the Director of Public Prosecutions and Lead Counsel of the state, Yvonne Atakura Obobisa, disagreed. She asserted that Mr. Marfo's argument was not strong enough to invoke a referral to the Supreme Court for an interpretation. She said there was no need because Part 23A of the practice direction is not at odds with the 1992 Constitution. She added that that part, contrary to Mr. Marfo's claim, actually seeks to give the defendant enough time to prepare for her defense and does not in any way infringe on her presumption of innocence. Mrs. Obobisa further pointed out that Mr. Marfo's claim that the practice direction's mandatory request for his client to reveal her witnesses contravened her presumption of innocence. A presumption of innocence could not be right because she could be acquitted after the prosecution's case, and that the manual does not force her to utter a word in defense if she chooses not to talk. She said the court will only decide that she mounts a defense after the prosecution has provided sufficient evidence against her. She noted that from the title, the practice direction is purely for the benefit of the accused and not the prosecution, adding that the manual's purpose is to ensure that there is clarity for the accused person in terms of evidence that the prosecution will mount in course of the trial. Moreover, Mrs. Obobisa said the manual's request for Mrs. Oware Mensah to file witnesses does not bind her to divulge any information she intends to use to defend herself. In Tijuana, state prosecutor neka say, "Oh, na sa asem we de anya asem bia. Ka asem we boni bi anim. In fact, na nka de aye kra no. Na nka ye wo client ne kra na beboa no. Asem a wo pejei enya asem de denden a obeka say aba wo mu anu hu nti ye de kodan Supreme Court da bi enya ne sa. Asem a wo ken de wuni uhwe mukra na wuni panokra na ade ne beboa no emra ne se ne ye embra na ye sa ade no ebeboa wuni pano na ye ka se on mount ne witness no ene interest by force ye pese wo kasa se wo hwe na se wo client no pese obe kasa on pese obe kasa e wo pre trial ye on pese obe kasa obian force ne se won kasa ati ase obian force ne se won kasa. Inti no enye big deal o hwe na so se onya we enya asem bia embinde no say on information bimbra if she intends not to defend herself, no one is forcing her. Inti de mu ye de entwa ye. Also, the call on the accused person at case management conference stage to disclose witnesses and their addresses is by no means a call on him to leave any evidence at that stage, and it carries no adverse consequences whatsoever at that stage. In the answer na case ebekoso no, ye wo ade bi efe case management, right? Answer na trial ebekoso no, ye wo bi efe case management. In the case management no, sa stage no, case management stage no, and you see one show ne witnesses or see one show and na ne lawyer e ka se dabi say at this point ye show witnesses ne dia na che se mo pese mo tre se ye di bone. Ade nso tre se ye ndi bone. Ti ho na states prosecutor no enso ka se dabi. Ene de enye bone bia ade we nye big deal. en emfa nso so boni bi amba ma me ne so emfa nso so boni bi amba ne witnesses ne so nti di ntia na asem mo pese mo twentwen so say the accused person is at liberty to state that I do not have any witnesses at this stage, just like the accused person, when he is called upon to open his defense at that stage, chooses to remain silent and not to open his mouth at all. It was a stage where any ebisa say or witnesses were here. To me, I say, at this stage, me need witness. I say never to aso. But oh yeah, they call court and they penny and they one now much as I say more accused. Not just say I say bibi she I say we nya sembia or say moye dia moye no. She asserted that part 5 of the practice direction makes it clearer that part 2(3)(a) is not at variance with the 1992 Constitution. Based on that, she said, this court ought to not refer any issue to the Supreme Court for interpretation because none arises for interpretation. After nearly 3 hours of listening to the submissions, the presiding judge, Justice Audrey Kokuvite, said she would take the arguments home and go and digest. She would take the arguments home and go and digest them. She adjourned the case to February 10th, 2026 for a decision on Mr. Marfo's motion to seek the Supreme Court. It's a honor judge ne case okay. Mutu ni na metie mu nsem. Mo ame fa nkofi yesi sumnie ema adwen. Mo ame fa nkofi na me nkoda so na me hwe se adwen no ehfa na one na make sense. Until 10th February mombra back na me man crofo enye den. So basically that's that. I say however, before she adjourned the matter, Justice Kokuvite stated that the dates for the trial agreed upon before Mr. Marfo's motion still stands. This means Mrs. Oware Mensah's trial continues on February 11th. Judge Irene say, but date na womo sha omo de be sha say womo edi ma me na asem ne de ensesa. O de opa ye de obeye date ne de ensesa. Intino. No. So that's quite interesting. Let's see. Let's hope it goes well. I mean, courts. Young Crawford say, "What's some year die? No one address will be winning court case that be." Sometimes lawyers need be on who say shenanigans ni nyama or ajaja. Muntra mo your comment box ni mo medasi.